In Wisconsin, your firearm can be taken from you in several situations: during a domestic disturbance arrest, under a domestic abuse restraining order because of an extreme risk protection injunction issued by a judge, after a felony arrest, or during a search when police believe the firearm is evidence of a crime. In today's video, we're breaking down exactly why firearms get confiscated in Wisconsin, what the law requires before they can be returned, the steps you must take to get your gun back, and real court cases that show how these laws play out in the real world. This is The Right Slant, and if this ever happens to you or someone you know, understanding the process is critical. Let's start by grounding this in reality. Wisconsin law gives law enforcement several legal avenues to seize firearms. First, domestic abuse incidents. Under Wisconsin Statute Section 813.12 and Section 968.20, police may remove firearms if they believe they were used or threatened during the disturbance. Second, domestic abuse or harassment restraining orders. If a judge issues a temporary or final injunction, the subject must surrender all firearms and cannot possess any until the order expires. Third, Wisconsin has a form of an extreme risk protection process, but instead of a standalone red flag law, it is handled through domestic-related injunctions. Judges can order firearm surrender when they find a risk to safety. Fourth, guns may be taken as evidence in a criminal investigation, whether or not charges are ultimately filed. And finally, if someone becomes prohibited under state or federal law, like a felony conviction, a firearm may be seized and not returned. All of these situations have very different paths to getting your gun back, so let's walk through them. The case statute in Wisconsin for getting your firearm back is Wisconsin Statute Section 968.20. This law requires law enforcement to return property unless the person is legally not allowed to possess it or the firearm is still needed as evidence. If the police or district attorney refuse to return the firearm, you have a right to file a petition with the court to challenge that refusal. Wisconsin law requires a hearing where the judge must determine: is the firearm still needed as evidence? Is the requester legally allowed to possess firearms? Was the firearm involved in or intended for a crime? If the answer to all three favors the owner, the judge must order the firearm returned. In State v. Perez, the defendant requested the return of a handgun that had been seized during an arrest. The trial court denied the return because Perez had a felony conviction, making him legally prohibited from possessing firearms. The Wisconsin Court of Appeals upheld the denial. This case reinforces a key reality: if you are federally prohibited, the court has no power to return the firearm, even if the gun was lawfully owned before the conviction. In State v. Jones, a firearm was seized as evidence, but the case was later dismissed. Jones petitioned for the gun's return. The state argued the gun might be connected to another investigation, but at the hearing they presented no actual evidence showing it was needed. The Wisconsin Court of Appeals ruled in Jones's favor, stating that the state must provide specific reasons why a firearm is still needed as evidence. Speculation is not enough. This case established an important protection. If the state can't prove it needs the firearm, you get it back. If you're finding this breakdown helpful, make sure you like, subscribe, and hit the notification bell so you never miss one of our deep dives here on The Right Slant. Here is the exact process for getting your firearm returned in Wisconsin. Step 1. Contact the agency that seized the gun. Ask whether the firearm is still being held as evidence and whether they intend to return it voluntarily. Step 2. Confirm your legal eligibility. You must not be prohibited under state or federal law, meaning no felony, no domestic violence conviction, no active restraining order, no injunction. Step 3. If they refuse, file a petition under Section 968.20. This is a simple written request filed with the clerk of court. You are asking the judge to order the firearm returned. Step 4. Attend the hearing. The state must justify keeping the firearm. You do not need to prove innocence. You only need to prove lawful ownership and eligibility. Step 5. If the judge orders the return, the agency must comply. Wisconsin law requires the gun to be returned unless a prohibition or evidentiary need exists. If your firearm was confiscated because of a domestic abuse injunction, it cannot be returned until the injunction expires. Once expired, you may file a motion with the court and provide proof of eligibility. The state may require a background check before releasing your firearm. Wisconsin gives law enforcement broad powers to seize firearms, but it also gives citizens strong protections and a clear legal path to get their guns back. Knowing your rights, understanding Section 968.20, and being aware of real case law can make the difference between losing your firearm forever or having it returned promptly. This has been The Right Slant, bringing you the facts, not the fear.